All right, so the title of my presentation is Student Discipline. All right, so what is the issue? Discipline in schools has changed over the last few decades. With the pivot to positive reinforcement as a major driving factor, programs such as PBIS are on the rise. However, schools still have to implement discipline in forms of negative punishment, which is taking things away, or positive punishment, which is adding a punishment, in some situations. There are restrictions and regulations on how schools can discipline students and what to discipline for. So, discipline has just become such a prevalent topic in schools, and thinking about administering discipline and how that's carried out, we need to look at the laws. All right, why does it matter? My school is a PBIS school, which means we use positive behavior reinforcements as well as teaching clear expectations of what to do as our main focus. It is important for schools to know what to do when setting up discipline procedures and what they can and cannot do in regards to student rights. Some teachers or administrators can implement disciplinary action without following protocol, which can lead to other issues such as violating student rights or the Constitution. So there have been a few situations where teachers administered discipline that they thought was appropriate. And it's important to look at what things can be disciplined just in respects to student rights and the other students' rights of the students in the room. All right, so we're going to take a look at Goss versus Lopez case.
February and March of 1971 proved a tumultuous time for the Columbus, Ohio public schools, marked by large-scale student unrest over racial issues. School officials responded by suspending students involved in these disturbances. Among those suspended was Dwight Lopez. Lopez's decision to fight back led to a constitutional confrontation with the school system in the case of Goss versus Lopez. In 1971, Lopez and 8 other named plaintiffs were high school students in the Columbus, Ohio public school system. At that time, Ohio state law required local districts to provide a free education to all children between the ages of 6 and 21. A statute also authorized a public school principal to suspend a student for misconduct for up to 10 days without notice or hearing. Lopez and the other students were all suspended from school for 10 days for behavior related to school disturbances. None of them received notice or a hearing before being suspended. The students sued the Columbus Board of Education and Columbus school administrators, including Norval Goss. They sought a declaratory judgment that the statute was unconstitutional because it deprived them of their right to an education without due process in violation of the 14th Amendment. The students sought to enjoin school officials from future suspensions and to clear any mention of past suspensions from their records. A 3-judge district court panel ruled that the statute was unconstitutional and ordered school administrators to remove all references to the students' suspensions from their files. The administrators appealed directly to the United States Supreme Court.
Okay, so the takeaways from this case is that when students are being disciplined, they should be given notice of violation and punishment and be given a chance to refute the charges. In addition, Carey versus Pythas found that students suspended without hearing could receive damages. Some other legal cases regarding school discipline. In the Ingram versus Wright case, the Supreme Court found that corporal punishment actually does not violate the 8th Amendment. Assault and battery suits are still possible if students are being exceedingly and unfairly punished by school officials. State courts are responsible for handling these cases. And although it is not found unconstitutional, it is still very controversial. And this graph shows, or this map shows, corporal punishment in schools is legal in 19 states. So you can see some of those states where it's still allowed. All right, students do not surrender rights when they come into the school, and they still have rights to free speech under the First Amendment. However, they are not allowed to speak in a way that is defamatory, obscene, lewd, or in a way that promotes illegal activity in public schools.